party. Good afternoon, sir. Please raise your right hand.
I think y'all should know me by now. I don't go through all of those formalities.
I did not know.
Sorry, I'm not going to swear in.
Could you state your name for the record, please?
I stand here as an authorized representative of the all capital letter name, CYWONHARDY.
Okay, and Ms. O'Keefe is with the county attorney's office. Still waiting for an attorney, Mr. Johnson and Mr. Gucciotto. Okay, this matter's on for trial. Sir, do you have an attorney who's going to represent you today?
You have to answer.
No.
Okay.
I'm sorry, Judge. I do believe Mr. Gucciardo was relieved by Your Honor on the last court appearance.
Okay, still on the calendar, but that is correct because the interested party was not interested. So we're just waiting for Mr. Johnson as the attorney for the trial.
Am I going to have to wait? Excuse me, am I going to have to wait here all day for somebody who's not here? And if they do not show...
See, that's nice. That when you just asked a question, you gave your short, curt response that you don't want to go through it because you've been through that already. And then you're going to stand in front of me before I even say anything and start making demands. I don't think that works.
I was asking a question.
So. Yeah, I know. And this is how I'm going to answer it. This is how I'm going to answer it. All right? So this matter is on for trial. I'm asking the county, are they ready to proceed with the trial once the attorney gets here?
Judge, we're just waiting for our witness, yes.
Okay. And I'll answer your question, but if you can answer my question first, do you have an attorney who's going to represent you?
There's no attorney here representing the all capital letter.
You had a question. I'll hear your question.
Yeah, I was just saying, am I going to have to be here all day?
No.
No. It's supposed to be at 2 o'clock,
yep.
And then I got to wait here, and then
and so the record is clear. It's about 2:30. I had another matter that I just checked them in, so they're conferencing it, and we're ready to proceed on the trial.
Okay, question. I want to know if Mr. Johnson does not come here today, and there's no witness that they were supposed to provide.
Then you can make an application for me to dismiss this case. I'll entertain that.
Thank you.
Okay, but since you don't have an attorney, let's go through some of the information. So you have the right to have the counsel represent you. That means you have the right to be represented by an attorney in this matter. You also have the right to hire an attorney of your own choice, or you have the right to ask an adjournment to speak with an attorney, even if you do not hire that person. As I pointed out in every court appearance, I'm still doing it again. I'm advising you of your right to have an attorney, especially since this matter is on for trial. You have the right to ask the court to assign an attorney, and if you are determined to be financially eligible, the court may appoint an attorney to provide legal representation and legal counsel. You can waive your right to counsel, and you can choose to represent yourself. But this is what they call a searching inquiry, and according to the laws and statute and case law, I'm supposed to go through this, so if you could bear with me, I'll hear what your position is, but I'm still going to go and give you the information like I have to. If you choose to represent yourself today, again, you may ask for an attorney at another time. If you wish to proceed without an attorney, the court must further advise you that you de-risk of self-representation and then conduct a searching inquiry, which is what this is going to be reasonably certain that the party understands the dangers and disadvantages of waiving your right to counsel. If you choose to represent yourself, you will be acting as your attorney, and if the case ultimately goes to trial, and that's what it's scheduled for today, some of your responsibilities will be, and could have been, issuing subpoenas, presenting testimony and documentary evidence, making and meeting objections to inadmissible testimonial or documentary evidence where there is legal basis to do so, and questioning and cross-examining witnesses, including experts, as an attorney would do. I'm going to give you all of this information, then you can let me know if you understand what I said, and if you have any questions, you can interrupt me, and I'll answer your question. Also, you should understand that you have the responsibilities by representing yourself, that you're going to be accepting the fact that, again, you have the right to challenge the witnesses. You have the right to presenting your own witnesses. You'll have the right to raise objections to any questions and any evidence that they seek to present. And by proceeding on your behalf, you'll be waiving your right to counsel and choosing to represent yourself, you're still going to be held to the same legal standard if you had an attorney to represent you. The court will not be able to advise or assist you in your self-representation. The outcome of this case may result in serious consequences for you, especially if I make a finding of neglect. Do you understand everything I said so far?
I heard you, and it makes sense to me.
Okay. And you're over the age of 18, correct, sir? What's your educational background?
I don't, no disrespect.
Yes, sir.
I just don't choose to answer those questions.
Okay, that's fine.
That they have anything to do with
What's your current occupation?
I don't wish to answer any of those
Okay.
questions.
What was your prior occupation?
I don't.
Have you had any prior exposure to legal procedures?
Like different court cases before?
Yes.
Yeah, I've been to court before.
Okay. Have you taken any drugs or alcohol which would affect your ability to make any decisions here today?
No.
Has anybody forced or threatened you or promised you anything in return for you making the decision to represent yourself today?
Well, I don't know. You said if I represent myself and I don't do good, then that could not be so good for me.
Yes, I'm advising you because this is a legal proceeding, and if we have a trial, which is it's scheduled for, they're going to present witnesses. So when they present witnesses, they go first. There's opening statements. They're going to present their witnesses after they do the direct and illicit testimonies. You can object to their questions, and then I will rule on it. For example, if it's hearsay. Then, after they finish, you have the right to cross-examine their witnesses. You don't have to say anything. You're the respondent, so you can remain silent. They have the burden of proving this case against you. You don't have to say anything.
Will my silence be considered acquiescence? Like, will it be considered that I'm
No.
agreeing
Again,
with what I'm saying?
you don't have to say anything. They have the burden of proving the case against you. There is some presumptions that can be held against you, but you have the right to remain silent. So I'm not going to take any presumption on your right to remain silent. You're entitled to that. And again, you made this decision. Do you recall me advising you of your right to an attorney in the previous court dates?
Right.
Okay, so the same thing applies. Do you want an adjournment to speak to an attorney?
No.
Do you want the court to appoint you an attorney?
No.
And so you understand that you're going to be representing yourself and you're giving up your right to counsel and you're going to speak for yourself, correct, in this matter? Correct. Okay, so I'm satisfied that you understand what's going on. As I just pointed out, there's been a number of court appearances in front of me. I'm satisfied that you understand and you made it quite clear to the court on the previous court dates and even today. Because I believe you also raised that there was no jurisdiction over you, correct? And I'll hear you further. Before we start the trial, counsel is going to give you a few more minutes to find out where we're going to page the other attorney. But as part of your opening statements, I'll hear what you have to say. So you'll be given an opportunity to address the court and give me your position if you want. You don't have to do that as well. Again, you can just remain silent. Okay, so let's page Mr. Johnson again. You can have a seat, sir. Do you want to sit there?
Can I have a copy of the information here?
Yes, sir. That's for you. Yes, you can have